Hi, everyone. Thanks for coming. I'm Brad from the Heaps Estrin team. This is Martha. And I guess this is the first of a series of discussions, informal discussions we're going to be hosting here at the lobby. And this one I'm interested in because I have 3 kids, and I know a lot of the people here, and they also have children. So this is a good one. A little about the lobby. We opened it about a year ago, and it's the genesis of the idea was just to connect with the community. It'd be a place where people could come in and get some ideas about real estate. We have a lot of artists, unsigned artists that come here and are exposed to the community. And I guess we also refer lots of our clients and people in the neighborhood to designers and architects in the area. So yeah, and it's been nice. It's been great. It's a great spot. So I hope you enjoy what we're going to talk about today.
So I'm Martha Grant. I'm also an agent with the Heaps Estrin team, and I've been in real estate for about 10 years now. I'm also the mother of 4, so this conversation is very interesting to me. I've got teenagers, so I've got to think about them wanting to live in Toronto or elsewhere, and how I might want to invest so that they actually have an opportunity. I also advise a lot of young couples and first-time home buyers, and often the first question they ask is about the bank of mom and dad. And sometimes that comes with sort of a negative connotation, like, ooh, do I want to ask my parents? And my first point of conversation is, you know what, open up the conversation. They've probably been thinking about it, and it's good to start now to see what their thoughts are. They may have already been investing for you, or they may want to invest for you. And then I often get involved with the families, and I find it really fun when parents are involved with their kids in buying a house. So it's often me getting to know the parents as well as the kids, and when having side conversations, whether I'm involved in the full family or I'm involved with the parents and then the kids, we find that we're often the intermediary between that. So I think we've got 2 amazing experts here today with Joanna Lang from Outline and Adam Richardson from Corman. So we'll introduce them, open up the conversation. They're going to lead a little bit of a discussion, and then we can all chime in and ask our questions.
Yeah, it's going to be a free flow. I'm going to introduce Joanna, who was my neighbor for, well, I thought it was 13 years, but it's more like 10. But our kids are all friends, and I'm going to read her bio because it's long. She asked me to shorten it, but Joanna is one of Outline's managing partners. Her approach to client service is unwavering. For the last 3 years in a row, Joanna has been recognized as one of Canada's top 10 brokers. She graduated from U of T with a double major in economics and industrial relations, and soon kick-started a career as a financial advisor with TD Canada Trust, later moving up the ranks to become a mortgage specialist in 2004. In 2012, Joanna and her husband, Jason, who I know quite well also, decided it was time to change professional course, and they set out on a life-changing entrepreneurial adventure. With her mortgage broker acumen and Jason's client management experience and his insurance, finance, and managerial expertise, the 2 founded the Lang team, who now have become Outline Financial. And they deliver strategic mortgage and insurance brokerage services for clients and a lot of Heaps Estrin clients as well. Joanna Lang.
Hello. Thank you.
And I'm going to introduce Adam. So Adam Richardson is a senior partner at Corman & Company. He advises on real estate transactions, primarily in the luxury market, but also cottages, and does a lot of pre-construction work. He has a joint law degree and business administration degree from Rotman School of Business and Richard Ivey Business School and Western. I would say we rely on Adam daily. He is such a source of knowledge on the legal front, and I advise that my clients speak to him at the beginning of their journey. I also, he's a great resource when it comes to some of the fine-tune, I wouldn't say issues, but issues and opportunities around real estate. And there's no question that he can't answer. So, yeah.
Thank you.
Without further ado.
Without further ado.
I guess,
Did I forget anything? Oh, and he has an amazing sense of humor. I said I was going to say that because you'll learn that today.
No pressure, right?
I think some of the things that like we're going to bring up, and I'm going to throw them out because I know I have questions on a lot of these, but multi-generational living, friends buying homes together, which is happening more and more, partners, when does common law kick in, which the answers to that are interesting, and I think they've changed recently as well. Foreign cash, pre-construction opportunities, things like that. So I don't know if anyone has anything off the top of their head they'd like to kick off with. If they don't, I have one. I have clients, I think I brought this up to you guys, but I've had clients over the years who, yeah. Oh, no, it's fine. I'm thinking one family in particular, and they have 4 kids, and about 8 years ago decided that they wanted a condominium in Toronto for each of their kids. And we've bought 2 so far, and they're still young, they still live at the house. But I just flip the leases for them. We rent them out year after year, and there's 2 more to buy. And so that's kind of their strategy. That's the main one that I've really heard of. I guess you could have duplexes, triplexes, and rent those out and have your kids move in. But that's certainly a way I would imagine, so that you can make money. It's an investment that makes money, but also ultimately a place for kids to live. So I don't know if anyone else has.
We'll definitely touch on that in terms of family gifting is gifting the property or investing for kids for their future use and how to build on that. That's all good questions. So maybe let's flow through some of the initial ones, initial ideas from Adam, because it's exactly what we're thinking as well. So in terms of the agenda, what we're going to talk about first is ways that parents can support their child in purchasing the real estate, which is some of those ideas. Ways to protect parents' money, which is why you all are here. How does a partner make a claim? What is the partner? What's common law? All those things. That's a big, big topic. Can my child buy a house with a friend? Multi-generational living. We're going to talk about investing in real estate before my child is ready to move. And then I'm going to take over and talk a little bit about a recent study from CIBC on gifting for down payment and what it looks like on average, and how do banks and other lenders view gifted down payment, and when it is a gift and when it is a loan, and what are the limitations. That's always a fun one. So without further ado, Adam is going to get started.
Thank you.
Do we need to do a formal disclaimer? Being a lawyer,
It's written there, but we'll give you a disclaimer anyways. This information is informational only. It is not legal advice. We give you the standard spiel that if you consult your legal professional with respect to your individual needs, so you can make a proper informed decision at that point. That is our disclaimer. But let's get started. So really the question, and I get this call probably almost weekly from clients and prospective clients. I have money, I would like to assist my client in buying that first property, or perhaps my client has, my child has saved some money, they're ready to put it towards a down payment, but they don't qualify for a mortgage. How can I help them? And then that's part A, how can I help them? And part B is how can I ensure that that money is actually going to be protected? So in terms of different ways in general that a parent can support their child, the most obvious one that first comes to mind is that you can give a lump sum gift. So gifting your down payment to your child. We're going to talk about what that looks like from the lender side in a little bit, but the idea here is that you are giving money, no strings attached, to your child to be able to purchase that property. And of course, there are a lot of caveats and hesitations that one may have with such a large sum of money being provided as a gift to a child, but it is certainly a way that it can be done. You can also consider co-signing a mortgage with your child. There are different ways to be taking title that can perhaps limit your capital gains exposure and maximize their first-time home buyer rebate for land transfer tax purposes. But you are at that point going to be going on title, possibly going on title, but definitely on the mortgage with your child as well. And you are going to be liable for that debt if they don't actually pay. The other thought that just first comes to mind is not necessarily gifting them that down payment in a lump sum amount or co-signing the mortgage, but trying to set them up with the different types of government incentives to be able to take advantage of those first-time homebuyer gains. So we're talking about the RRSP first-time homebuyer allowance where they can take funds out towards that first transaction. We're talking about the tax-free first-time homebuyer savings account that's also available. Your child may need assistance in contributing towards those investment accounts to be able to, again, take advantage when they're actually ready for that first purchase. So when we're talking about, okay, we're going to give that money to the child, they're going to go and purchase that property, or perhaps you're co-signing, they're going to purchase still that first property and you're helping them with the mortgage qualification. What happens with respect to that future partner, or if they have somebody in their life at this point that they might be moving into the property with? And we're talking about this from a cohabitation romance perspective right now. We're not just talking about two people living there together who don't have some sort of a relationship. That will be covered in a little bit. And the big one that is often forgotten, but is probably the most important aspect for clients to consider, is making sure that there is a cohabitation agreement in place before that partner moves into the property. And I'm being very careful not to talk about somebody who's legally married yet, because that is a different can of worms. But we're talking about somebody who has, a partner who's going to be moving into that property. Once that partner moves in, and again, we'll talk about this in a second, they do have different types of claims, notwithstanding whether or not they are common law or legally married. There are different types of claims that they can still make against that property. So it is almost like having a prenup in place, but just property specific. And you set out what the rights and responsibilities are of those two individuals, who's contributing what were to happen if that person was to move out of the property, what would be in the event that they sell the property. And while there certainly are, I'm using the word property a lot, you can tell that there's a real estate aspect here, but there's also a very strong family law component as well. So while we're certainly happy to take a look at cohabitation agreements, we often recommend that they are drafted by family law counsel. And again, that reason being is that you want to make sure that you don't have issues when the parties hit different definitions of being spouses. And if they were to become legally married, move into that property, how does it impact the parties' claims? The other aspect just to consider is oftentimes, parties will come to a real estate lawyer. Perhaps the partner and your child are buying the property together from the get-go. In that type of a situation, we're acting for both buyers jointly. So we're not able to take on one side over the other in terms of drafting a cohabitation agreement. So that is, again, where separate counsel comes into play. Family law counsel is definitely important to be working with, but a family law counsel that has a real estate background would definitely serve your clients best. So that is option A, and that is the one that you will often hear a lawyer advise you to consider, but it is one that doesn't generally come to mind. The one that does generally come to mind is, I'm giving my client a gift, or I'm giving my child a gift, but I want to secure it on title. How can I do that? And it is very important to kind of understand the inherent conflict in that question alone. You can't gift something to somebody. A gift is no strings attached, here's money, and then secure it on title saying it's a loan. The two do conflict with one another, but nevertheless, it is a great way to protect family assets. So if it's not a true gift, and if your client is perhaps child is going to be buying that property all cash, we often see parents fronting that money, securing the amount on title. It can be done by way of a promissory note, so an IOU, secured by a charge, so a registration on title, so that if someone was to come into their lives in the future and move into that property, they're only making a claim really against that appreciated equity in the property, which again can arguably be dealt with through a cohabitation agreement, but the vast amount of like equity that's sitting in the property today is already going to be construed as a liability. It's money that's owed back to the family itself. And it can be done through pulling money out of a trust and loaning it to that child. It can be done through parents loaning the money personally to the children. There are different ways to consider it, but again, it actually zaps out the equity that's currently available and protects that family gift to begin with. And we'll talk about how that comes into play with a mortgage, like a traditional institutional mortgage, because that isn't as clear cut, but client buying all cash certainly can be a way to do so. In terms of that partner, we have concerns. You know, your standard concern that everybody will think of is Family Law Act. Somebody is married, it's the matrimonial home. You can't sell or mortgage a property without your spouse's consent, even if they are not on title. And you can have more than one matrimonial home. So we're thinking about that property that's in Toronto as well as the cottage that might be up north. Those are both matrimonial homes. It doesn't matter if one person or both are on title. You need both spouses to be consenting to those types of transactions. But aside from that, you're considering, okay, well, what about common law? At first glance, common law doesn't have the same type of proprietary rights, so you don't have the obligation to ask your common law spouse to consent to a sale or a mortgage of a matrimonial home, because there is no matrimonial home. They are not spouses, deemed spouses pursuant to the Family Law Act in terms of being legally married. But there are other types of claims, and these are two very important ones to be aware of. So dependency claims have nothing to do with the property themselves, but it says, I'm getting used to my style, like the type of living that you've been providing to me. So my partner is affording me a certain type of lifestyle. I've become reliant on it. Maybe I don't, seek the other type of job that has a higher payout in relation. I'm therefore, if my partner were to try and sell that property and I was to lose out, I would be making a claim against that individual saying, I have a dependency, I am actually dependent of you, and therefore, you have an obligation, a fiduciary obligation towards me, and your only asset happens to be the property. How convenient. Maybe I'm entitled to a piece of that property being sold. So that is a type of claim that we can see people making. The other type would be a constructive trust, and that one happens more often than not. And that's where you have a situation where you have two people, they're living at the property, one person owns, but that other person is contributing. They have a good relationship, everything's fine, but they're agreeing to contribute towards the overall household costs. So maybe there's an amount of the mortgage that's being contributed towards, or just overall housekeeping expenses, or food, or whatever it is, time being spent maintaining the property, like both time and money. And they would therefore argue that they've actually, there's a constructive trust that has been created by reason of their investment in the property, that they are now owned, like they're owed back money at that time of sale. So not great. We want to try to avoid these types of issues, and it can be avoidable. Again, the cohab agreement is definitely an important one. You could, I don't generally say you need to do both, but every case is a little dependent. But having a co-ownership agreement, I think, is immensely important to protect that child when there is family money that's being provided. And again, if you are providing that family money all up in front, like as a lump sum amount, and there is no mortgage that's going on in relation, you probably don't want to give your child that ability to just sell the property, cash out, and do whatever they want with that money. And that is where securing the gift on title, so it doesn't become a gift, it's actually a promissory note, so securing the loan to the child on title by way of that mortgage, that ensures you, again, from being able to have some control over the money that you've provided through the bank of mom and dad. The other question that comes up, not as much, but certainly it is something that is more prevalent in this industry, is, what can I do if my child wants to buy a property with their friend? And we've been talking about a romantic relationship on one side. This is just purely friend. And if you're going to be doing that, it's okay. There are different types of phrases for these types of agreements, either a joint venture, but more commonly a co-ownership agreement that is almost like a cohabitation agreement. It just doesn't talk about the same aspects of like what happens if you actually, end up getting married, and what are those going to be, those types of implications. In this case, it's more who gets what part of the property. Like for example, maybe they get their own exclusive use of their bedrooms, but they have an agreement as how to share some of the common areas. We've certainly seen that before. How are you contributing money towards it? What happens if there's a cash call? What happens upon the sale? If one person wants to buy the other person out, how do you value the money like the asset itself, and how can that actually be carried out? It definitely works. It works better, I would probably say, when the children are coming up with the funds, more of the funds themselves. You always have to keep in mind that if you're being asked to co-sign a loan for your child as well as somebody else, their friend who's going to be buying the property with them, you're on the hook for that friend's exposure as well if they decided not to pay. And perhaps in that situation, it's a better opportunity for you to have a conversation with you helping that child buy the property altogether and then renting out a room to that friend, as opposed to being exposed to that friend's liability as well. It's a lot easier when it's within the family, but when there isn't that familial relationship, you co-signing a loan can be a bit more of a concern. But nevertheless, if you have two parties who are fully able to buy properties and they can pool their money together and actually buy a better property, and they have a mechanism that allows them to kind of deal with their disputes and how to value property and what happens at the time of sale, then that really does alleviate a lot of that stress between that co-ownership relationship, and it is an opportunity. So pros and cons, but it is certainly an option that is available to like friends that want to buy a property together.
Part of that, we were going to talk about family arrangement where family lives together, or you're buying with your kids.
Like multi-generational. So multi-generational certainly works. There are many creative ways in order to take title in these types of situations. You have to really decide, who is the person that is buying that property, like where's the cash coming from, and what do you want to happen with that person's interest at the time of, an eventual passing. Like we're thinking about parents or grandparents that are living there as well. It's doable if everybody is not on title, they don't have a legal right to stay at the property. That's something certainly to consider. But if you were to have, for example, parents and child all living together, we sometimes will see a situation where perhaps they want to take title jointly, so that's called joint tenants, which means the last remaining survivor of the whole of the property acquires it, and it passes outside of the estate. It's not subject to estate administration tax, it's not subject to land transfer tax, it's just the last remaining survivor acquires the whole of the property. There are other situations where maybe that isn't how you want to be administering your estate. Maybe there are other children who you aren't living with, and you need to deal with some sort of an equalization at that point. And that's where you would want to be certainly working closely with your estate planning professionals to have equalization provisions in the will, so that if you, God forbid, if you were to pass, the amount that is being received by the child that you're living with can be set off in relation to the other assets that you have as part of your estate. So aspects that you want to consider. It can be very case by case, but again, there are ways to make this happen to allow your clients or enable your children to be able to go and buy those properties.
What about if you have an extra property that you want to gift to your kids?
Very good question. Thank you, Joanna. So that is another one that we see, and this is one you have to be very careful about. So we call this double taxation. So definitely doable, but if you do it wrong, there's a much greater tax bill that you're going to see at the end of that tax year. So let's give you the example of parents who have a property. It's an extra property. They're willing to transfer it to their children. Without going too much into the tax details, there is a deemed disposition at fair market value because they are related parties. So the parents are deemed to have sold the property for fair market value, notwithstanding what they've actually transferred it to the children for. So there is a capital gain that may be incurred by the parents on that side of it. Not necessarily if they've been living there throughout their entire duration of ownership of the property as their principal place of residence and are claiming the principal residence exemption. But we're not going to go too much into that. On the child side, you have to be careful, because if you are selling the property to your child at a discount, so you're not fully gifting it to them, but you figure, hey, I'm going to gift a portion of the equity, they're going to pay me out another cash dollar amount, and then they're going to get a mortgage for whatever that amount they're going to pay me for, and because the equity gift has reduced that loan to value, it's a lot easier for them to qualify for the mortgage. I hope I'm not going to lose you guys, but their acquired cost base is now the amount that they've purchased the property for. So when they turn around and sell the property, they're going to have a capital gain. The profit is going to be calculated based on the sale price less the amount that they bought the property for. But the parents have already paid tax on the value of the property at fair market value at the time of the transfer versus what they bought it for. So there's an overlap in tax that's being charged twice, once to the parents and once to the children. If the children are acquiring the property for free, it's a $0, payment. It is an actual true gift, not even $1 or $2, $0. Then the child's acquired cost base is now deemed to be fair market value. So when they go ahead and sell, now your capital gains actually align and you don't have that overlap. So you need to be careful about what you're considering. You need to be considering what it is, like what type of property it is that you're trying to gift. Do you have the cash to pay the tax associated with it? Or does it make more sense perhaps to sell that property and use the proceeds to help them buy the next one? It's very much so case by case, but these are the sorts of questions or thoughts that we wanted to leave you with. Yes?
And I presume there's land transfer tax on that.
If it's a gift, a true gift, like gift of equity, no land transfer tax. If there is a cash payment, it would be like based on the amount that the children are paying the parents for. So it can be a reduced land transfer tax, that part's great, but it's the capital gain that really gets you at the end.
Does it change the scenario where, like my clients who are using it as an investment property first and then give it to one of the kids, does that change the equation at all?
They're going to have a capital gain.
Yeah.
Yeah.
Which they would have anyway in both
If they were to
sales.
sell it anyways.
Right.
But if they were to sell it, there's sale proceeds to pay for your tax obligation. Whereas if you're gifting it and then you have a tax obligation without the money, you have to have you have to have money aside essentially to be able to pay for that tax burden.
I have a question. So if it's a blended family and there's two partners coming to buy a house, they both have sets of kids, how do they buy the house to protect their children so that when the first, say in a tragic situation, one partner dies, you don't want necessarily the property to go to that other partner and their children. How do you
Right.
protect your children?
So in that type of a situation, like, again, I realize it's their next marriage or just relationship and they have the trust there for one another. But if you hold title jointly, that deceased individual's share goes to the surviving spouse. And if they choose to change their will, or their will is currently set up in a way that only gives to their children, then that means that the first deceased, like that first partner's children, they miss out. And it's a tragic result of improper estate planning, essentially. In that type of a situation, you would probably want to have a tenants in common relationship where there's certain percentage interest in the property altogether. You could have a cohabitation agreement on the side that dictates what were to happen when you were to sell the property. But more likely in terms of this question, if one of those two were to die, their interest in the property passes to their estate, and then it's dealt with in accordance to their estate. So presumably, their children would receive a share. Without going too much on a tangent, it is still important that spouses, like with blended families, they have to be very careful with their estate planning, because you don't want to have a situation where you've agreed upon everything to be split between all of the kids, one person dies, and then the next person rewrites their will. So that is something that we would certainly encourage you to talk to your estate counsel about, because that would take very careful drafting to achieve the right outcome there.
And a key message there, I think, is that those discussions need to be had early in the process. So it's not a rushed, put it together thing 2 days before closing. And I think that's the key message on any of them, on considering a gift, how you're going to gift. When we talk to young couples for a mortgage and they say, okay, one of the parents is contributing a big chunk, we will ask them right there and then, have you had conversations with your lawyer? I said, they're going to talk to you about it 2 days before closing. You should probably approach that subject sooner. And same thing with investment properties. We can refer or collaborate with client's accountant, and we can share the constraints that we see from financing or from legal perspective, and how can we balance that out with proper tax planning or estate planning.
Yeah, I always like to say we always have clients that come to us, and it's on the sales side. So they're about to close their deal and they say, well, how do I do this in a more, tax advantageous way for me? And it's like, well, that should have been considered when you were buying the property. Like now your taxes are essentially a reflection of what has happened throughout your duration of ownership, and now the bill just happens to become due. So you need to be careful about and to have these conversations and to have the proper planning at the time that you're buying that property, and probably before you even enter into the agreement, to make sure that you're very happy with the tax consequences on the other side. But yes, we're more than happy to provide referrals, and we're always happy to chat about it as well before you have even signed an agreement of purchase and sale.
I think none of us are happy with tax consequences, but just some of the pain is worse than other.
Exactly. It's a pro and con conversation for sure,
yeah.
differential.
And I think knowledge is power, because I think sometimes what happens is people rush into putting that agreement together, and it's a stressy market when you know that you see a house you love and it could be in multiples and you're in that position. So making sure you've had the conversations with someone like Joanna and Adam ahead of time is really a responsible thing to do, and helpful to us as agents too, because we can provide a little bit of those conversations and that knowledge, but it's not 100% our expertise, especially on the night of the offer when we have to give that advice. And luckily we do have these guys who we can text and ask questions to, but the first conversation I have with new clients is just asking them about, where the money's coming. Have you thought about how you want to be on title, and all those conversations? So encourage you to have those conversations with your agent ahead of time before you start looking.
Absolutely. So I'm going to jump into the financing part of it, because it's always a balancing act. What do you want to accomplish and what you can if you are taking a mortgage? So let's just jump in some of the details. But first, I'm going to start with a trivia. The answers are there, so it's not really a trivia. CIBC, Benjamin Tall, chief economist at CIBC, did a study a couple years ago, just looking generally at what percentage of first-time buyers are getting a family gift. As of 2021, it was 30% of all first-time buyers got a gift from family towards the down payment.
Or Toronto?
That's Canada-wide,
Okay.
and that's up from 20% 6 years earlier. Average gift in Canada was $85,000. Average gift to a first-time buyer in Toronto was $130,000. We certainly see that, and if you think about almost a third of first-time buyers getting help, it's a large number. So hence this seminar, we see it a lot.
Do we feel that the 3% might be a bit low? I know anecdotally in Martha's experience, you think it's higher. Mm-hmm. And do we think maybe the stats are a bit compressed because it's not counting students who are coming in from overseas with financing? That 3% just feels low to me. I'd like to know your take on it.
In terms of me seeing people coming to, I would say it also, I think, because this is a Canada-wide study, I think it depends where and what.
Gotcha.
So it's hard to judge. Yeah. What about people who are, moving from their first place to the next, the mover-uppers? And that amount is 9%. And that's often a surprising number, because these people maybe already got a gift first time around, or they didn't. And now they're moving to a more expensive home, and parents are still gifting money. On average, that's 9% of repeat buyers. Average size of a gift across Canada, $128,000. Average gift for a mover-upper in Toronto, $200,000.
So it's more than first.
Yes, but hopefully they've done well with the first gift, so they're getting a bigger one. It is a smaller percentage of people who are getting a gift. But I think it's a big factor. And what I want to mention here, without giving anybody any tax advice, what are you hearing more and more? Family gifting as part of wealth planning, and what's called a living will. You are able in Canada to give a gift to your kids, and again, not giving anybody tax advice, but to my understanding, this is tax-free. So a lot of people, as part of their overall tax planning, might decide to transfer some of the wealth to kids earlier, so then that money is transferred at the time when then the kids can use it to better their living conditions and also start growing equity in their property tax-free. Because don't forget that anybody who purchases principal residence in Canada, principal residence is tax exempt. So if the kids get a new property 10 years down the road, if it's worth $1 million more, that's a tax-free return. So if you gifted them a few $100,000, that money might have helped them now build a lot more equity and tax-free. So I think that that's the understated part of why this is happening, because people are transferring wealth earlier.
Joanna, when we use the word gift, are we talking inheritance too, or is it just living? People are living and getting that? Because when you're buying a second home, often it's inheritance that helps you.
Inheritance is then it's essentially after
Different?
probate tax money. So the will goes through probate, the government takes their piece, and then you get the money, and then you do what you please with it.
Right, so that's not included in that
I would still be going to get a cohabitation agreement if you got it from. I think that's the one thing if everybody remembers from his presentation, cohabitation agreement. But absolutely.
You're almost saying as well, like I think you alluded that the 30% number, which maybe is higher, but it could be a product of people being smarter with their money.
I 100% think so. There's properties are expensive, so it's harder for that first-time buyer to actually get property in Toronto. But B is especially for people like in Toronto, I would say that number 9% is probably low. And working in Midtown, 200 grand. There's lots of gifts that are way bigger than 200,000. And I'm finding it's the grandparents who now grandparents, because the kids now have kids, they want to be in a better school district, they want to do this, they want to do that, and they're contributing to let the kids buy a house in a neighborhood that they want, to be in a school district that they want. So it's overall financial planning as well. That's been my experience, but that's just my 3 cents there. So I'm going to move in and talk a little bit about physical logistics. What does the bank think about the gift? How do they look at it? And it is invasive when it comes to verification of gift. And the first thing I'm going to say is sometimes people might feel like, well, why do you need information from me? Because there's also something called Anti-Money Laundering Act. And anytime you have down payment for a purchase of a property, the money has to be sourced, where it came from. So as much as someone who is gifting the money might not want to be exposed to having to tell the bank where the money is coming from, but the reality is doesn't matter what's the source of down payment, it has to be sourced for anti-money laundering rules. And that's just something that the banks have to do, or they will get a fine. When the banks are assessing the gift, and because there's always a worry from a bank perspective, is it a gift or is it a loan? Or is it a non-arm's length transaction? So they want to know who is the giftor. Is it a parent, a grandparent, a sibling? Or is it a friend's cousin? They typically are not going to be okay with a friend's cousin's nephew gifting you the down payment because it's not a typical transaction. And why is this person gifting you the money? What kind of interest they have in the property? So you're going to be asked about your relationship with the person who you're gifting to. And the farther out it gets, then it's up at discretion of the bank if they still consider this a gift, or are they worried that the other person has some kind of other interest in the property.
So ultimately, is that call, I think I heard you say the banks. So like if I don't have any siblings, don't have any kids, but I might be contributing to my cousin's children. Like that's a once removed, is that a second cousin once removed? I don't even know, but that might not fly in terms of the gifting protections.
So we would have to then just provide a bigger explanation. What's happening? And then maybe, it's an uncle who doesn't have his own kids or whatever, or does have kids, but we have to really provide the story to make the bank feel comfortable. Why is this person gifting money, that they're not a stranger, because then they probably have interest that's not disclosed. That's the thinking behind it. So when you're getting asked all those questions and getting annoyed by them, this is the thinking behind it. So hopefully that eases some pain. How do banks look at verify gifted funds? So the bank, and what's a gift, what's a loan, we'll talk about that in a minute. But if you're gifting your kid the money and you're not going to be doing it as a loan, then they'll make you sign a gift letter form. And that says that this is a true non-refundable gift, because some people, if it's a loan, it's not a gift anymore. But we have to sign a gift letter. The money has to go into the kid's account. So sometimes the giftor might want to wait until last minute and send the money to the lawyer right before closing. That would be an exception. And then we have to get giftors' bank accounts and confirm more details. Typically, we don't need the bank accounts of a giftor. In some situations, yes, but if the money goes into the kid's account and there's some period between when the money gets in there and closing, then we might not need further details other than signed gift. But in some cases, we might have to verify actual investment statements. And what about timelines? If the funds are coming from abroad, there's more government regulations about funds clearing in Canada, and also banks' comfort level of having money pop in from another country and then pop out for a real estate transaction. So in my view, what we always tell clients, money has to be in Canada at least 45 days before closing. Lots of people will say 30 days before closing, but what they really mean is 30 days. We need to have it there for 30 days to be file complete to get ready for closing. So if you don't have that period of time, banks get nervous. They want to make sure that the money clears, settles, and it goes through the system. When it comes to, that's the most common question we get 99% of the time, this one. Can the gift be registered on title as a second mortgage? And unfortunately, it's either a gift or a loan. The gift is not registered on title as a lien as a second mortgage. And this is going to tie in with what Adam was talking about. Gift is a non-refundable amount of money that you give to your kids, and you're going to sign that letter and say that I am not getting that money back, okay? And if the parents choose to register a mortgage on title and have it as to protect the money, and they say, okay, I'm gonna give you that money and put a lien on your property, so if something goes wrong with that boyfriend in 5 years, and you sell the property, I'm going to get my money back. If they want to put a lien on a property, the bank has to agree to it. And what happens then, so let's say they buy $1 million property. The government changed the rules a few years ago because the B lenders were doing the bundle mortgages, and the rules changed for everybody and everything the same. The total lien on the property, on the client who has at least 20% down, so not a CMHC insured mortgage, total lien from the bank plus the second mortgage to the parents, second lien, cannot be more than 80%. So if your child is buying for $1 million, you're providing 20% down, and then the bank is doing the mortgage for $800,000, you cannot register that on title because it's illegal to go 100% at closing. The government doesn't allow it. So that's one problem right there where you can't register a second mortgage. And so let's say that your kids have $200 of their own money, the total financing is $800,000, you're giving them $200 and the bank is giving them $600, where the total debt is no more than 80% of the value. In this situation, the bank still has to factor that loan into the qualifying ratios. So you might say, oh no, I don't want you to pay me anything. They're going to pay me if something happens. There's, again, not giving legal advice here. For the lien to be actually viable, there has to be an interest rate attached to it and some kind of payment schedule, because then it could be argued by the ex-boyfriend that it actually wasn't a loan. So we need to then, that child has to qualify for that gift as part of the borrowed funds, and we have to put it in our calculations.
So, again, every case is different, but it would probably make more sense in that type of a scenario that you have a cohabitation agreement ready for any of, your child's future partners to be living at the property with them, and an equalization provision likely in your will to account for the fact that you have gifted some money to your child already. That would probably make the most sense, but again, it's case by case for sure.
Yeah, and I'm finding that, with rates being as high as they are right now, when average person has to qualify it at 8 or 8.5%, we're, September 2023, so hopefully that comes down. But it's hard to qualify, and if we have to include those extra numbers, in some cases what might end up happening is parents might end up being joint on a deal, maybe as 1% owner on title, so it doesn't take away from land transfer tax rebate and all the other rebates. But we have to really weigh in all the different factors.
And you want to think about the fact, like, clients will say to us, oh, don't worry, I'm just going to go to a different lawyer afterwards and register my charge on title after the fact. Well, now you're committing an active default under the first mortgage. So you have to decide if it's really worth it. It's oftentimes not. And again, like, you've signed a gift letter, your child has that gift letter, you've now registered a charge in support of a gift, everything is in conflict. That's likely not the best way to secure the money. It's like there are other ways, which we've been discussing. In those situations, it's probably that cohabitation agreement that's the right thing to be doing there.
Yeah, and if you're doing it because you're worried, then might as well do it right? So that there's nothing to worry about. But yeah, we see all kinds of scenarios, and we would just recommend just doing this.
For a young couple, what's the going rate for sort of a simple cohabitation agreement?
I would probably say you're looking somewhere between like $1,500 to $2,500. They're going to have to get their own counsels to give them separate advice. So it just really depends on how complex it is, who's drafting, how much time for independent legal advice, that sort of thing.
I'm just going to add one more thing in terms of, when we see the deals, and then there's one of the couple is the income earner, and I'm not talking spouses, just boyfriends, girlfriends, whichever stage they're in at their relationship. But if one person has all the income and they have all of the down payment, then the bigger decision is, are we adding that other person to the deal, or do you have a side agreement with them that maybe they will participate in appreciation of a property in some way? Because the divorce rate in Canada is, 40-something, 50%? A lot of relationships fall apart. A lot of friends buying together. If that goes wrong in 3 years, then this person has to buy them out, pay them out, there's a cascade of things, and then maybe they have to redo their mortgage and so forth. So that the bigger discussion is just having a discussion up front. Yeah, we see some of those things. I'm going to jump into the last piece that we have here. We started with buying investment properties, and we're going to end with investment properties. It's a different story when you're purchasing a property for children who are underage, and maybe you're holding title of that property under your name or under a holdco, and having tenants pay down the mortgage. It will have a different tax consequences and so forth. But the one area that's maybe a little bit under appreciated is if you have an 18 or 19-year-old, they're nowhere ready to move out, probably till they're 30. I don't know. I'm joking. But a lot of if you have young people who are 18 or 19, they're going to university. They might have a few years before they will be ready to get the place. There is opportunities in new construction where you could purchase a new construction contract under their name, give them the down payment as a real estate deposits, and that property, depending on a project, could be 3, 4, 5 years, or an assignment maybe a little bit less, but you could invest into them purchasing a principal residence sooner, and hopefully, if you buy a right product, like with any property, that value of a property will go up, and by the time they are ready in a few years, then hopefully you've built up some equity in the property, and you didn't have to carry the mortgage or have a tenant, and it's in their name. So there's just another idea of what we sometimes see.
Yeah, I think it's a really great opportunity for You have to be careful, when you sign a pre-construction agreement, you have 10 days for condos to have them reviewed. We always recommend sending it in. We have a document review team. We give a full written review. And I think it's really important because there are other areas you do need to navigate in pre-construction, certainly additional costs that you'll see at closing. But the overall benefit can certainly, it can certainly still be the right type of opportunity for your needs. You just need to be aware and cognizant what it is that you are buying, how that deal is going to work, what is that process, what's it going to look like, what are the time frames as well, do they align with your kids' needs? But yeah, if you can buy something today that's not going to be ready for 5 to 6 years and you think your kids are ready to close at that point in time, that's great. And otherwise, plan B, you help them close and you look at some other opportunities at that point, but it can be a really attractive option.
And Joanna used the word assignment, and that can happen. Say you go into this deal and halfway through or at some point you're not comfortable with it or your circumstances change, then you can sell it on assignment and usually make some money even before the move-in date. So that's an opportunity too.
And on the flip side, if you have a child who you think might be ready now that you didn't think was ready before for that pre-construction property, you may be able to be on the buy side to find an assignment where the assignor, so that original buyer, is no longer interested in proceeding with the deal. There are lots of opportunities right now in the market to get into assignments, to not pay a huge appreciation over that period of time that the property's been sitting. So another great way to get your kids into something that's brand new.
Just make sure you do your diligence on who the companies are building. There's so much diligence, so make sure you trust your real estate team and your mortgage advisor and your lawyer, because there's a lot of junk out there right now. And so it's navigating that too to make sure you're in the right building.
Assignment is its own big presentation.
Yeah.
And there's so much flash. As we drive up Yonge Street, you see all these new presentation centers, and people are going in and going, wow, oh my God, I'm going to be in the palace. And then when they eventually look at their floor plan, it's 600 square feet. But there's an amazing party room and gym and rooftop patio. So you just have to be very thoughtful of that process too. And that's what we're here for. So.
Any questions?
Yeah, it's a lot.
We effectively put everybody to sleep.
And we can give these presentations to you too.
Do you want to talk about cottages for a minute?
Sure. So I mean, there's a lot to unpack there, but the biggest question with cottages generally is, how do you plan for intergenerational, planning with respect to the asset? And I wish there was a simple answer I could give you, but when the cottage is passed down and there are multiple siblings and families, they have their own respective families that are in play, that is usually where there is some interfamily tension. Is that the right way to put it? That can certainly ensue. And what's the division of cost, time, what happens if one wants to sell and the other doesn't? So it's not a one solution fits all approach, but it is extremely important to have realistic conversations with your children about what is going to happen with that family asset. Is there one child who's more interested in taking over or has the financial means to take over the responsibility of the cottage? Do you have enough in terms of your asset base to be able to equalize out the distribution? So is the cottage, is the amount of the cottage, do you have that dollar value sitting in cash or other investments that you can give to the other children to set off the distribution to that child as well? If not, they then would probably have to buy the cottage from the estate in order to keep the cottage and not have it, equalized across the children, if you don't want to have all of the children being on title itself. There are certainly types of familial agreements with respect, almost like co-ownership agreements with respect to how you deal with the cottage. But at the end of the day, if the kids aren't going to be getting along, they are probably going to make an application pursuant to the Partitions Act or, through their litigators to try to force the sale of the property or have somebody buy them out in order to just kind of cut your ties and be clean with that. Is that?
Yeah. Do you see a trend towards cottage trust, or do you usually see a trend towards death and estate issue?
I don't know if it's one or the other, but we certainly see that when the property is fully held, like it's fully been paid off, there's definitely a conversation that's had with estate counsel. And I do real estate, but I know a little bit of the estates on the side, but there's definitely a conversation with respect to nominee planning. So that's where you roll the property into a trust. There's a numbered company that's on title. A secondary will is drafted so that the asset is not subject to probate, and the shares and everything are just passed through without the need for probate at that point, so that you have the ability to pass the property again to that next generation. But it doesn't solve the problem of, is there enough money in the estate to deal with the distribution? It also doesn't, it's certainly, when the property is appreciated, it's certainly okay, but I think, and we saw this in the papers recently, where properties have now started to devalue. Perhaps people bought the general cottage areas have been fine, but people bought in much more remote areas thinking everything was going to be okay and continue to go up. And that's the real estate market. But in those areas where they've seen perhaps greater softening, there's a greater push towards that intergenerational familial planning, because they don't want to essentially suffer a loss at the time of death, or whenever the parents decide that they want to sell. They want to pass it on to the kids, allow for future benefit for those generations. But there's a lot to unpack there. Capital gains exposure, what's the principal residence exemption, lots of tax aspects for sure.
What's been great about your responses is the integration of so many different types of expertise.
Yeah.
Assuming that you're not having a transaction happening in the next 3 to 6 months,
Yeah.
is the best sort of expert to start with family counsel, or is it real estate? If we know it's a heavy asset conversation, which expert should I start with?
I would probably start with your estate counsel. Okay. So, what do I do when I die? Essentially, that type of a lawyer, because I think there needs to be a real conversation of, do I have enough money in my assets right now to be able to give this gift and treat all of the other kids fairly? I think that's step number one. Step number two, just in terms of the order of the lawyers, when you are looking for that property, you're going to want to have engaged a family law lawyer to get started on that cohabitation agreement. If you were to have, let's just even say it's your kid and their partner that are buying that property together, but you're giving a gift and you want to make sure that there's a proper division at that time of potential future breakup. If they sign if they sign all of their closing documents with me and we close the deal, there is no requirement on that other partner to agree to sign the cohabitation agreement. It's like a prenup that's being signed after you've been married, a postnup. That you don't have the same type of leverage. So you do want to make sure that that type of documentation, the format of the agreement, everything is ready to go, so that when you found that property, it's just an easy signature, and it should be done. It really should be done before closing. Otherwise, you're exposing yourself to a lot of just potential litigation and a claim that would encroach upon your gift. You'll certainly want to have a real estate lawyer. So feel free to reach out, and I'm happy to answer those questions as well. We get clients that often will ask questions before they've started the offer process. And again, we would direct them to have these conversations with their other counsel as well, working tandem all together to make sure that you have the appropriate outcome.
And, I think that a lot of people worry about who is perceiving what, how, what is their boyfriend going to say to sign. And I've done thousands of transactions, literally. I've been at it for so long. And we have this conversation all the time. And when that couple comes in, and there's a big chunk from one side and not much from the other side, when they're coming together, they don't expect that if they split up in a year, that's going to be split 50-50. That's not the expectation. They really want to be fair to each other. They love each other. They want to do it together. So the expectation is, at that point of love and coming together, and there's a punchline here, that, yeah, it's fair. If, I'm going to sign a cohabitation agreement. If we split up in a year, then you should get your money back. But sometimes amnesia hits later, if things don't work out so well later. So doing it up front is actually not an awkward conversation at all. Everybody says, yeah, it makes sense. Just add it to my list of to-dos. So
it shouldn't be a surprise. It shouldn't be offensive at all.
I think it's really important. I always joke that my kids seem to divulge so much information to me that my parents didn't have to hear. And sometimes I think, oh my gosh, it's crazy. But I've got a son. My son's living with his girlfriend right now. And we set up his bank account when I could have access, so I can still see it. But I'm doing counseling, early counseling with him around equal sharings of the grocery bill. I'm like, there is no way she's paying for groceries and you're out of money. So let's sit down. So the other day I sat with the two of them. I have a good relationship with them. And I was like, guys, you guys need to start thinking about this early. And so let's talk about your grocery bills. And they kind of were like caught off guard. But it's similar. If you start with your kids at an early stage and you have those open dialogues, I think then as you go through the process and say they're buying a house with their girlfriend, boyfriend, partner, then they're going to be more comfortable in that situation too. I know they have to protect themselves, so.
And if you bring this up and the spouse of the other party is really upset about it, red flag.
Yeah.
Yeah, maybe at the beginning and then, yeah.
I was gonna skip that part, but
Yeah.
I would run. Yes.
Anyone else have any thoughts or questions?
We can send these presentations around if anyone wants them. If they want to email info@Heaps Estrin.
Yeah, if you didn't register with the Eventbrite link, feel free to email that. And if you want the copy, we can talk to our experts and go from there.
Awesome. Thanks, guys.